Hello, my name is Irene Rwakazina, and I'm a Consumer Safety Officer in the Compliance Enforcement Branch within the Office of Scientific Investigations at CDER FDA. Our office is responsible for the compliance and enforcement activities related to the administration of the FDA's Bioresearch Monitoring Program, which is responsible for oversight of the conduct and reporting of FDA-regulated research. In this role, our office is also responsible for the review of requests and the issuance of discretionary certificates of confidentiality for CDER-regulated drug products. In this presentation, I'm going to provide an overview of certificates of confidentiality. In the presentation, I'm going to discuss what a certificate of confidentiality, also called a CoC for short, is and its purpose. I'm going to go briefly over the laws that provide for the protections conferred by a CoC, and then I will provide a definition of identifiable sensitive information as defined by these laws. Then I will discuss the disclosure protections that having a CoC affords the CoC holder, as well as the exceptions to these protections. And then I will touch on the application of a CoC, including the difference between a mandatory CoC and a discretionary CoC. And finally, I'm going to recap the key messages and provide some useful resources. A certificate of confidentiality, which going forward in the presentation I will refer to as a CoC or a certificate, is a document issued by a U.S. federal agency to a researcher who is engaged in biomedical, behavioral, clinical, or other research in which identifiable sensitive information is collected or used. The certificate protects the privacy of individuals who take part in the research by prohibiting the CoC holder from disclosing names or any information, documents, or biospecimens containing identifiable sensitive information to anyone who's not connected with the research. There are limited exceptions to these disclosure protections, which I'm going to discuss a little bit later in the presentation. There are two federal laws, the Public Health Service Act, or the PHS Act for short, and the 21st Century Cures Act, or Cures Act for short, that provide for the protections conferred by a CoC. The PHS Act came first and initially added protections to prevent researchers from being compelled to disclose human subjects' identifiable sensitive information in any federal, state, or local civil, criminal, administrative, legislative, or other proceeding. The Cures Act came later and amended the PHS Act and broadened these protections by prohibiting CoC holders from also disclosing such information to anyone who's not connected with the research unless a specific exemption applies. The Cures Act extended the disclosure prohibition to others also involved in the research, such as contract research organizations, clinical investigators, and academic institutions, among others. So, what is identifiable sensitive information? Identifiable sensitive information, as used in the PHS Act and the Cures Act, means information that is about an individual and that is collected or used during the course of research, and through which an individual is identified or for which there is at least a very small risk, as determined by current scientific practices or statistical methods, that some combination of the information, a request for the information, and other available data sources could be used to deduce the identity of the individual. You will notice that the law focuses on the identifiability of the information and not on the sensitivity of the information. And identifiable information isn't limited to a person's name and social security number only. Other information, such as address, birth date, genetic information, and tissue samples, for example, used in combination with other information, may lead to identification of a study participant and would also be considered identifiable. CoCs protect research participants by prohibiting the disclosure of identifiable sensitive information for studies collecting information that, if disclosed, could have adverse consequences for participants, such as negatively impacting their employment or insurability. For example, research on mental health, research on the use and effect of alcohol and other psychoactive drugs, and research that collects or uses genomic data. Once a CoC is issued, the CoC holder must comply with the statutory disclosure protections in the PHS Act. Other entities with whom the researcher shares the information, such as contract research organizations, clinical investigators, and academic institutions, etc., are also subject to these disclosure requirements. The CoC holder is prohibited from disclosing or providing to any other person who's not connected with the research the name of any individual from the research study or any information, document, or biospecimen that contains identifiable sensitive information about the individual. These protections prohibit the disclosure in any federal, state, or local civil, criminal, administrative, legislative, or other proceeding. The information and all copies of it are immune from the legal process and are not admissible as evidence and cannot be used for any purpose in any action, suit, or other judicial, legislative, or administrative proceeding. The protections under a CoC do not expire. Even with a CoC in place, however, there are certain circumstances under which identifiable sensitive information may still be released. This information may be released if required by federal, state, or local laws. For example, if required by the Federal Food, Drug, and Cosmetic Act, or by state laws that require the reporting of communicable diseases to state and local health departments. It can also be released if necessary for the medical treatment of the person to whom the information, document, or biospecimen pertains and made with the consent of this individual. It can be released if made with the consent of the individual to whom the information, document, or biospecimen pertains, or for other scientific research that is in compliance with applicable federal regulations governing the protection of human subjects in research. CoCs fall into one of two categories. They can be mandatory or discretionary. Mandatory CoCs are automatically issued for federally funded research. The issuance of mandatory CoCs is required by law, and each federal agency handles the CoCs for the studies that their agency is funding. For example, FDA, NIH, and CDC. So if your study is federally funded, you do not have to request a CoC. Typically, the language regarding the CoC is found in the contract or notice of award for studies that are funded by a grant. Discretionary CoCs, on the other hand, may be issued for non-federally funded research. The issuance is not required by law, but a researcher can request FDA issue them a discretionary CoC for a study they are conducting if that study involves an FDA-regulated product. Although mandatory CoCs and discretionary CoCs are issued under different processes, the protections that they afford are identical and the legal responsibilities are the same. To learn more about CoCs, you are encouraged to read the FDA Guidance Document on CoCs. This guidance document describes the revised, streamlined process for submission to FDA of requests for discretionary CoCs for non-federally funded research. This process minimizes the burden to researchers who request a CoC, and it streamlines the existing process by reducing the information currently provided in a request to FDA for CoC. And it also clarifies the statutory responsibilities associated with receiving a CoC and reduces the time it takes to obtain a CoC from FDA. This guidance document is a great resource, and it can be accessed using the web link on this slide. In summary, I would like to leave you with some key messages that I hope you will take away from this presentation. FDA and other federal agencies issue CoCs. CoCs are issued to researchers who conduct biomedical, behavioral, clinical, and other research that collects identifiable sensitive information about research participants. CoCs protect the privacy of research participants by protecting researchers from being compelled to disclose identifiable sensitive information in an illegal proceeding. Researchers are also prohibited from disclosing this information to anyone who's not connected with the research. Even with a CoC in place, however, there are certain circumstances under which identifiable sensitive information may still be released. Here are some resources that you may find helpful to learn more about CoCs. In addition to the FDA Guidance Document that I previously discussed, you are also encouraged to watch the corresponding video about CoCs presented by my colleague, Kelly Nolan. Kelly's presentation covers an overview of FDA's role and responsibilities with regards to CoCs and how to request a discretionary CoC from FDA. For CoC questions about research regulated by FDA's Center for Drug Evaluation and Research, please send an email to the email address listed on this slide. For CoC questions about research regulated by other FDA centers, please send an email to the corresponding email address listed on this slide. Thank you for your time.